全体队列，敬礼！备备！安首席法官，全體隊列列隊完畢，請你檢閱。仪仗队，过奖！仪仗队，起步，走！全体队列，敬礼！备备！首席法官你好，請批准全體隊列經過檢閱台向你致敬並且離場。儀仗隊，向右走！仪仗队，过奖！仪仗队，起步，走！加油！
莅臨法律年度開啟典禮，為免影響典禮進行，請將手提電話轉為靜音模式，並關掉其他響鬧或發光裝置。為確保典禮莊嚴有序，典禮過程中嚴禁拍照、錄音或錄影。多謝合作。Welcome to the ceremonial opening of legal year. To avoid disturbance during the ceremony, please set your mobile phone to silent mode and switch off other beeping or light-emitting devices. To maintain the solemnity of the ceremony, photo taking, audio or video recording is strictly prohibited during the ceremony. Thank you for your cooperation. 欢迎莅临法律年度开启典礼。为免影响典礼进行，请将手提电话转为静音模式，并关掉其他小闹或发光装置。为确保典礼庄严有序，典礼过程中严禁拍照、录音或录影。多谢合作。 主禮人士現在進場，請各位繼續就座。Please remain seated when the official party proceeds onto the stage. 主禮人士現在進場，請各位繼續就座。 現在準備奏唱國歌，請各位肅立。Please stand solemnly for the playing and singing of the national anthem。現在準備奏唱國歌，請各位肅立。請各位就座 ，Please be seated。請各位就座。
Secretary for Justice, Chairman of the Bar, President of the Law Society, fellow judges, distinguished guests, ladies and gentlemen. On behalf of the Hong Kong judiciary, I extend a very warm welcome to you to the ceremony of the legal year. This significant occasion serves as a timely reminder to our community the role an independent judiciary plays in upholding justice and the rule of law. It also offers an opportunity to reaffirm the core values on which our legal and judicial institutions are founded. The judiciary's work over the course of 2025 is set out in detail in its annual report, published electronically today. In particular, I have provided an overview of the key areas of work undertaken during the past year in the welcome remarks. This allows me, in this year's speech, to devote attention, first, to some fundamental principles essential to the rule of law and judicial independence, which have been brought into focus by a recent case, before turning to another topic concerning the constitutional roles of the different branches of government in the protection of rights. The long criminal trial of Mr. Jimmy Lai and his companies before the Court of First Instance of the High Court has recently concluded, resulting in the convictions for national security and conspiracy offenses. Sentencing remains pending, and appeals may or may not be forthcoming. As expected, the outcome of this high-profile trial has attracted significant international attention and commentary. Also, as expected, given the prevailing geopolitical tensions, some of these responses have been critical, not only of the prosecution and verdicts, but also of the courts and the rule of law in Hong Kong generally. It is important to emphasize at the outset that the legal process remains ongoing. The defendants retains the rights to appeal. Any alleged errors, whether legal, procedural, or evidential, will be considered by the Court of Appeal, should an appeal be lodged. For obvious reasons, I will not comment on the merits of the case or make categorical assertions about the proceedings. The appropriate forum for resolving any such issues remains the judicial process itself. However, I would like to take this opportunity to highlight a number of general matters of importance. To begin with, we fully respect the right of individuals to express their views. Few court decisions please everyone. Rather, the strength of our justice system lies in its adherence to the law and its openness to scrutiny. In this respect, it is no different from those in other developed common law jurisdictions. However, a comment or a criticism is only as meaningful as it is informed. Any serious comment or disagreement intended to be taken seriously must be grounded in a careful reading of the judgment and a sincere effort to understand the court's reasoning. Hong Kong's basic law and general laws, along with the national security laws, all guarantees the independence and impartiality of the courts and the right to a fair trial. They require that court decisions be based on the evidence and legal arguments presented, and not on extraneous considerations or public pressure. These fundamental principles govern all criminal proceedings in Hong Kong. Save for narrow and well-defined exceptions, all criminal trials are conducted in open court, in accordance with established rules of criminal procedure and evidence. Members of the public, as well as the press, are permitted to attend hearings without undue restrictions. Invariably, the prosecution bears the burden of proving the defendant's guilt beyond reasonable doubt. Both the prosecution and the defense are entitled to call witnesses, tender documentary and other forms of evidence, and make legal submissions. Unless they choose to represent themselves, all defendants are legally represented at trial, either by privately instructed lawyers or by those funded through the public purse. If they wish, give evidence in their own defense. If they choose not to do so, the prosecution may not comment on that fact, and certainly no adverse inference may be drawn from it to establish guilt. Unless the case is tried before a jury, all verdicts are accompanied by reasons. These typically explain the charges, summarize the prosecution's case and the defense, describes the evidence adduced, and set out the court's reasoning for its findings and conclusion. This transparent process, which is followed in all criminal trials with necessary adaptations where appropriate, ensures accountabilities and enables full and meaningful appellate review where required. At the risk of staying the obvious, it should be noted that court decisions are subject to appeal or review in accordance with the applicable procedures. I have every confidence that the Court of Appeal, and ultimately the Court of Final Appeal, will, as always, act with integrity and professionalism in handling any appeals or reviews. Under the basic law, the courts, as the judicial organ of the Hong Kong Special Administrative Region, are under a constitutional duty to hear and determine all cases that are properly brought before them. They concern themselves only with the law and the evidence, not with any underlying matters of politics, policies, or other non-legal considerations. As professionals, our judges take seriously the judicial oath to administer justice fairly and impartially. Any suggestion that a judge would compromise their conscience or integrity for political or other extraneous considerations when hearing a case is, by its very nature, a serious one that should not be made without cogent evidence. Bold and unsubstantiated allegations of this kind merely indicate that the criticisms may themselves be influenced by political or other extraneous considerations. as to sweeping comments on the state of the rule of law in Hong Kong, arising from the outcome of a particular case. Many of us may be forgiven for growing weary of simplistic assertions that the rule of law is dead whenever a court reaches a result one finds unpalatable. The rule of law in Hong Kong is far more robust and enduring than the outcome of any single case. It cannot be that the rule of law is alive one day, dead the next, and resurrected on the third, depending on whether the government or another party happens to prevail in court on a particular day. Such a claim needs only to be stated to highlight how untenable it is. As regards calls that are sometimes heard to halt proceedings or prematurely release a defendant based on reasons such as occupation, background, or political causes, it should be emphasized that such demands not only circumvent the legal procedures established to ensure accountability under the law, but also strike at the very heart of the rule of law itself. A foundational tenet of the rule of law is that no one is above the law, regardless of their status, occupation, office, political affiliation, personal belief or conviction, popularity, wealth, connection, or any other characteristic. The law applies equally to all, without fear or favor. Those who are genuinely committed to upholding the rule of law must also be committed to allowing the courts to do their work according to established legal processes and without interference. As to the threats of sanctions that have been made from time to time against our judges, it is clear that however these threats are framed, they are, in substance, attempts to interfere with judicial independence by means fundamentally at odds with the rule of law. Intimidation and threats are no different from bribery and corruption, they being, in truth, two sides of the same coin. Both are means of subverting justice and have absolutely no place in a civilized society governed by the rule of law. I will now turn to a different topic concerning the respective constitutional roles of the judiciary, the executive, and the legislature in the protection of rights. It is without doubt an important aspect of any constitutional framework. The Hong Kong Special Administrative Region is established by the Basic Law pursuant to Article 31 of the Constitution. In matters of fundamental rights, the Basic Law, along with the constitutionally entrenched Hong Kong Bill of Rights, provides a legal framework within which all public authorities must act. I will first start with the courts. Their constitutional function is to adjudicate independently, applying legal principles to the facts before them and making reasoned decisions. In the constitutional or public law case, where it is alleged that the government has breached or failed to protect a certain right, the court must carefully consider the claim by reference to the right asserted and any other related or competing rights or interests, the existing case law, the evidence adduced, and the justifications put forward in defense of the subject matter under challenge. If a case for breach is not made out, it is dismissed, usually with cause. If the case is established, the court must so hold and determine what remedies, if any, should be granted. In some instances, a legislative provision or administrative rule may be reinterpreted to eliminate the offending part where possible. Where that proves infeasible, the court may have to strike down the provision or rule altogether, rendering it of no further legal effect. In other cases, the court may simply grant a declaration, that is, a formal court statement of the legal position concerning the rights, obligations, or status of the parties or other relevant matters. In all cases, the court's decision must be accompanied by clear reasons. Parties and stakeholders alike, as well as the public, are entitled to understand how the law has been interpreted and applied. Courts exercise great care in granting legal remedies in constitutional and public law cases. Often, they leave room to the government to determine, in accordance with the rule of law and principles of good governance, how best to fulfill its constitutional or public law duties. Judicial restraint in this context reflects constitutional discipline and a recognition of institutional limits. Courts administer justice by applying the law. They seek neither to govern nor to legislate. In fashioning remedies, courts strive to uphold both the substance of the rights at issue and the proper division of constitutional functions. Before turning to the executive, it is important to say something about the finality of judgments on the interpretation of a provision in the Basic Law or of a right guaranteed by it. When the Court of Final Appeal gives judgment on such a matter, its interpretation represents the authoritative statement of the law, subject only to any interpretation by the Standing Committee of the National People's Congress, and then only in prescribed and exceptional circumstances. The court's interpretation binds all, the public, the administration, and the legislature, including individual members. This upholds the design of the Basic Law, which vests the power of final adjudication in the Court of Final Appeal. To say that an interpretation of the final court is binding on all is simply to recognize what the Basic Law expressly provides regarding final adjudication. Respecting the court's judgment is simply respecting the Basic Law. People are, of course, entitled to hold different views on controversial matters. They may also express disagreement with a final judicial interpretation does not provide a legal basis to depart from it. The constitutional space for debate lies not in reopening a judicially concluded matter, but in determining how best to conform our system to what is protected under the Basic Law as finally interpreted by the court, taking into account all legitimate and relevant considerations. The responsibility for compliance and for taking remedial steps ordinarily rests with the executive. Naturally, most decisions that give rise to constitutional or public law challenges, whether concerning welfare, immigration, taxation, or public administration, are executive in nature. The executive operates the policies and systems that govern our society. It is typically the respondent in judicial review proceedings, and it has both the duty and the capacity to bring its policies and systems into compliance. Depending on the facts, remedial measures may involve revising administrative policies and guidelines, modifying existing systems and procedures, reallocation of resources, and, where primary legislation is required, introducing a bill supported by policy reasons and, where appropriate, public consultation. This duty flows directly from the rule of law and the constitutional imperative to uphold the basic law, including its protection of fundamental rights. The legislature, in turn, exercises a distinct and constitutionally protected role. Its members are elected to scrutinize, debate, and enact legislation. They do so under an oath to uphold the basic law. That oath establishes a constitutional framework, but does not dictate how members must vote in relation to individual bills. Courts are careful not to intrude upon the legislative process and fully respect the legislative discretion that the legislature enjoys. Some have sought to explain this judicial restraint by drawing comparisons with the United Kingdom, where Parliament is sovereign. It is in many ways a natural reference point, but not an equivalent model. In the United Kingdom, the Constitution is largely unwritten, political in nature, and crucially, Parliament is supreme. No court can strike down an act of Parliament. No institution, including the judiciary, has the authority to dictate what Parliament must or must not enact. The legal authority of Parliament is absolute, and its enactments are binding regardless of content. Hong Kong's constitutional order is different. Our constitutional framework is written and legal in nature. Our public authorities, including the legislature, exercise their powers under the Basic Law, which itself derives from the Constitution. The Basic Law defines the scope and limits of institutional authority. Within that framework, the courts are tasked with interpreting and applying the Basic Law with finality, subject to and within the legal parameters set by the Basic Law itself. It is for the executive to propose legislation where required, Legislative Council to consider and enact it as it deems appropriate. In this way, our system preserves both constitutional discipline and space for legislative discretion. In practice, what emerges is a constitutional division of labor, with each branch of government operating within its constitutional role. Even on occasions when consensus between them proves elusive, at least for the time being, the system does not grant to a halt. The court's judgment stands as a vindication of the affected individual's rights and triggers the executive's duty of compliance under the law. As a result, incompatible administrative rules may fall away, and governmental policies and practices may evolve. New measures may emerge to alleviate the position. The resulting picture may not be perfect or seamless, but it reflects meaningful constitutional progress. And that, too, forms part of the constitutional model established under the Basic Law. By definition, controversial matters attract divergent views. Public confidence in the rule of law need not be affected by the presence of differing perspectives on these matters between the branches of government. Far more important is the respect each shows to the other and their respective constitutional roles, with each branch maintaining its role and a robust respect for the rule of law. We believe that even complex, multidimensional issues can in time be worked through with both principle and practicality. Last but by no means least, every one of us in the judiciary shares in the deep sorrow felt throughout our community in the wake of the tragic fire that occurred in Wangfuk Court in last November. This horrific incident resulted in a devastating loss of life, inflicted great suffering on only too many families, and caused extensive damage to homes and property. As the community moves forward, our thoughts remain with those affected as they work to recover and rebuild in the aftermath of this tragedy, supported by many across our society. For its part, the judiciary has announced measures to expedite and prioritize legal proceedings arising from the tragic fire. A task group led by the Chief Judge of the High Court has been established to oversee handling of cases across all court levels. In addition, a support team has been set up to manage probate matters and liaise with relevant departments. Probate-related fees for deceased victims will be waived, with other fee concessions to be considered on a case-by-case basis. The judiciary will continue to draw on support from the legal profession as appropriate. It only remains for me to wish you and your families good health and a peaceful year ahead. Thank you.
Chief Justice, members of the Judiciary, Chairman of the Bar Association, President of the Law Society, distinguished guests, ladies and gentlemen, the ceremonial opening of the legal year is not merely a ceremony. It's a unique annual event for the judiciary to speak out on important issues and for representatives of the legal profession from both the public and private sectors to show our support to the judiciary and pay tribute to judges and judicial officers for their contributions. There's no question that in the past year, as is always the case, our judges and judicial officers have performed their duties conscientiously and professionally. But most of their work will be of interest to the parties directly involved in court proceedings only, and will not receive any public attention. Court news reported in the mass and social media were focused on a small number of cases, in particular, national security cases which were considered to be of public interest. Comments and discussions on these cases are generally permissible because of the freedom of expression and freedom of the press. However, these freedoms do not include making unfounded accusations against the integrity of our judiciary. It's disappointing and frustrating, though not entirely surprising, that the judiciary has been subject to such unfounded accusations due to judgment delivered in a number of highly charged national security cases last year and recently. Worse still, some of these accusations were misrepresented as facts and used as pretext to advocate imposing unlawful sanctions against judges involved in those cases, and to put illegitimate pressures on foreign non-permanent judges of the Court of Final Appeal to resign. One of the duties of the Secretary for Justice is to act as the guardian of public interest and the due administration of justice. This is why I feel obliged to take this opportunity to refute these unfounded accusations. This is extremely important because unless disabused, they may undermine people's trust and confidence in our judicial system and the rule of law in Hong Kong. Hong Kong's success as an international center in finance, trading, and other areas, as well as people's general sense of security, depend very much on the perception of and trust and confidence in our judiciary. Let me put things in context first. It is a fundamental principle of international law and international relations that every state has the inherent and inalienable right to defend its national sovereignty and territorial integrity, and to choose its political, economic, social, and cultural system without interference in any form by another state. Very recent events in other parts of the world and recent statements made by some foreign politicians concerning the territorial integrity of other countries, including ours, sound a warning bell that it will be naive to assume that these principles will necessarily be followed. Concern over national security is anything but fanciful and must be taken seriously. Having said that, it is not and never the national policy of China to pursue absolute security. Under the relevant national law and the Safeguarding National Security Ordinance, national security is defined as a reference to the status in which the state's political regime, sovereignty, unity and territorial integrity, the welfare of the people, sustainable economic and social development, and other major interests of the state are relatively free from danger and internal or external threats, and the capacity to maintain a sustained status of security. I would like to emphasize the word relatively in the phrase relatively free from danger and internal or external threats. It does not say absolutely free from danger and internal or external threats. Our country clearly recognizes that it's essential to strike a balance between security and development. I explained in the white paper titled China's National Security in the New Era, released on the 12th of May last year. China strives to achieve a positive interaction between high-quality development and high-level security, and promote mutual reinforcement and coordinated enhancement between opening up and security. Not only that there's no conflict between safeguarding national security and promoting development of Hong Kong by ensuring that it remains an open, free, and diversified international city. Maintaining national security as defined under the law indeed provides the indispensable precondition for any development to take place in a safe, stable, and peaceful environment. Having regard to the significance of national security, Article 3 of the National Security Law, the NSL, imposes a constitutional duty on the executive, legislature, and judiciary of Hong Kong to effectively prevent, suppress, and impose punishment for any act or activity endangering national security, and I quote, in accordance with this law and other relevant laws. In the present context, it's pertinent to note the two following set of legal provisions which prescribe the role of the judiciary and shed light on how it should discharge its constitutional duty in this respect. First, under Articles 2, 19, and detailed provisions in Section 4, Chapter 4 of the Basic Law, the judiciary is vested with and shall exercise independent judicial power, including that of final adjudication. Second, Articles 4 and 5 of the NSL provide respectively that human rights shall be respected and protected in safeguarding national security, and that the principle of the rule of law shall be adhered to, including, for example, no one shall be convicted and punished for an act which does not constitute an offense under the law. A person is presumed innocent until convicted by a judicial body. the right to defend himself or herself, and other rights in judicial proceedings that a criminal suspect, defendant, and other parties in judicial proceedings are entitled to under the law shall be protected. Having regard to these two sets of legal provisions, in national security cases, as in any other type of case, the court's duty is to conduct the proceedings fairly and properly, ensuring that human rights are respected and principles of the rule of law are followed, to construe and apply the relevant laws to the evidence, and then make its decision, all done independently. In considering the validity of any criticism that's been made against the courts in those highly charged national security cases, the correct question to ask is whether there's any ground to support that the courts have failed to discharge their duties as I have just described. There are a number of factors which can assist us to answer this question. First, it's important to observe what happened in the course of judicial proceedings, which were all held openly. Have the judges ever, without any good and sufficient legal reason, stopped the defendants from giving evidence or making submissions, or cross-examining the prosecution's witnesses? Has any of the judges made any inappropriate remarks indicating that they had bias or prejudice against the defendants? Did anything otherwise happen which would suggest that the defendants had not been treated fairly? I'm confident that any reasonable and objective person who has attended and observed those proceedings will answer all these questions in the negative. Some might opine that the proceedings have taken a long time. I would say the time was well spent and necessary to ensure that there was a fair trial to all parties concerned. Second, it's essential to study the judgments in those cases, which is indeed what people have been asked to do repeatedly. The judgments are of utmost importance because they explain how and why the judges came to their conclusions, and in criminal cases, why they were satisfied that the defendant's guilt had been proved beyond reasonable doubt. To be more specific, how they construe the relevant laws, what evidence and submissions they had considered, accepted, or rejected, and why, and how they apply the relevant laws as they understood in the light of the evidence and submissions which they had accepted. A sufficiently reasoned judgment also serves another important purpose. That is to reassure people that the courts have not taken into account any irrelevant and improper considerations. Let me ask, in those national security cases, is there anything in the judgment which would suggest that the judges have taken into account any extraneous consideration, or that somehow their independence has been compromised? I'm again very confident that the answer must be a resounding no. Some people may wonder why the judgments are so long, running to hundreds of pages, and might even question whether they need to be so long, entailing long judgment writing time. The length of judgment is largely dictated by the amount of evidence and submissions heard and the complexity of the issues involved. In cases which we take great care to ensure that the judgments were reasoned for reasons that I have just explained. Third, it's worthwhile to note that in national security cases, the government was not always the successful party. In a case involving many defendants, 2 defendants were acquitted after trial in May 2024, and the prosecution decided not to appeal against one of the acquittals. In March 2025, the Court of Final Appeal quashed the conviction of an offense under the implementation rules for the NSL. These incidents are an unequivocal evidence that the judiciary has been able to exercise and has in fact exercised independent judicial power in national security cases. As the unsuccessful party in those cases, the government would naturally be disappointed. If there were reasonable grounds to appeal, we would invite the appellate court to reconsider the matter. If the judgment was final, the government would review whether the outcome was caused by any deficiency or inadequacy in the relevant laws, and we so would seek to amend the same. There's one critical point that I wish to add. On those occasions when the court ruled against the government, it would be unfair and incorrect to suspect, merely because of the outcome, that the court might have failed to appreciate the importance of safeguarding national security, and that they had not discharged their constitutional duty in this respect fully and properly. Fourth, in response to intimidation made against judges, the judiciary has reaffirmed in various statements in the past that all judges and judicial officers exercise judicial power independently and will continue to abide by the judicial oath and firmly discharge their duty in the administration of justice without any interference. There's absolutely no reason whatsoever to doubt the veracity of these statements. Enough is said about national security. It's important not to lose sight of the big picture that every year the judiciary handles tens of thousands of civil and criminal cases of many different types, playing a key role in resolving disputes and maintaining the law and order of society. In some of these cases, particularly those decided by the Court of Final Appeal, the courts develop important common law jurisprudence, which makes significant contributions to not only Hong Kong, but also the common law world in general. An excellent example is that just 10 days ago, on the 9th of January, the Court of Final Appeal, in a scholarly and landmark judgment, held that it's appropriate to recognize the tort of harassment as a development of the common law in Hong Kong. However, a company cannot sue for harassment because it's incapable of suffering emotional stress, even though it may seek an injunction to restrain acts of harassment directed at its officers, agents, and lawyers. Apart from performing judicial duties, the judiciary has made tremendous efforts and contributions to promote the rule of law and enhance Hong Kong's status as an international legal service and dispute resolution center in other ways. On behalf of the Department of Justice, I would like to express my gratitude to members of the judiciary for taking part in the work of the Law Reform Commission, the Working Group on Mediation Regulatory System, and the Working Group on Arbitration Law Reform, as well as various capacity-building programs organized by the Hong Kong International Legal Talent Training Academy. The rule of law, based on our common law system, is one of the most, if not the most distinctive and crucial advantage of Hong Kong under the principle of one country, two systems. Members of the judiciary, the Department of Justice, the Bar Association, and the Law Society play different roles in our legal system. We may not and need not agree on each and every issue. In judicial proceedings involving the government sometimes succeeds, sometimes fails. But all that said, our solidarity, courage, and determination to maintain and enhance the rule of law in Hong Kong is unquestionable. Lastly, we are still in January, and the Chinese New Year, of course, will arrive in less than a month's time. So may I conclude by wishing you all a very happy New Year. Thank you very much.
Chief Justice, Secretary for Justice, President of the Law Society, judges, distinguished guests, ladies and gentlemen. On behalf of the Hong Kong Bar Association, I would like to extend a warm welcome to all of you at this ceremonial opening of the legal year. 2025 was another busy year for our courts and the administration of justice. I will deal with some developments relating to our top court. As our apex court, the Court of Final Appeal plays a pivotal role in the administration of justice in Hong Kong. To this end, Hong Kong is fortunate to be able to call upon the best judicial minds locally and from the rest of the common law world. In January last year, the term of office of Lord Hoffman as an overseas non-permanent judge was extended until early 2028. His lordship has been a strong supporter of the rule of law and judicial independence in Hong Kong since he started sitting in 1998. In the last summer, Sir William Young, an eminent jurist from New Zealand, was appointed as an overseas NPJ. Sir William served on the Supreme Court of New Zealand from 2010 to 2022. The Bar strongly believes that Hong Kong and its people greatly benefit from the present arrangement. Article 82 of the Basic Law provides that the CFA may, as required, invite judges from other common law jurisdictions to sit on the CFA. This was and remains an ingenious and very wise design, one which has enabled our final appellate court to benefit from the experience of top jurists in the common law world and which has helped ensure that the court's decisions accord with generally accepted principles of the common law. Given the composition of the CFA, the development of the common law in Hong Kong will always be one which is appropriate for this jurisdiction and in line with its actual circumstances. The presence of overseas NPJs has a positive impact on the perception of our judiciary both within and outside of Hong Kong. I will address this aspect shortly when I deal with the importance of perception and how in the real world perception affects reality. One notes the proliferation of international commercial courts around the world. Many have spoken of the benefit of such institutions to the economy. This is consistent with the fact that many international financial centers are in common law jurisdictions. What Article 82 envisages and enables is far more remarkable. Rather than confine overseas judges to sit only in commercial cases, as if that were an area of law that stands separate from the rest of the legal system, our basic law enables overseas judges to assist in other areas of our law, including criminal law, constitutional, and administrative law. It is to the distinct advantage of the people of Hong Kong that our jurisprudence in all areas integral to our legal system can develop with the input of eminent overseas jurists working together with world-class Hong Kong permanent judges in ensuring that the development of our common law is consistent with Hong Kong's unique circumstances. In terms of our permanent judges, it was announced in last September that Ms. Justice Ribeiro would be reappointed for a further term of 3 years from March this year. Mr. Justice Ribeiro's reappointment was universally supported by the legal professions, including members of the Bar. He has served on our top court since 2000, and his erudite judgments have been cited in many common law jurisdictions. It has been a matter of shared experience between counsel from both Hong Kong and overseas to find their carefully constructed arguments shown to be unsustainable after just 3 or 4 questions from his lordship. In terms of jurisprudence, the court has in the past year dealt with a wide range of significant legal matters, including the necessary ingredients to prove a conspiracy to defraud, the jurisdiction of a Hong Kong court to issue letters of request to a court in the mainland, the claim to public interest immunity and its impact on the right to a fair trial, which is essential, amongst other important legal issues. International litigating parties favor jurisdictions like the United Kingdom, Singapore, and Hong Kong to resolve their disputes. As Lord Burnett noted in a lecture he delivered in 2022, a study carried out by the English Ministry of Justice a decade ago concluded that one important factor that influenced the use of their courts by international parties was the reputation and experience of its judges. Reputation and experience are both consequences of the meritocratic basis for appointment from amongst the most experienced practitioners from the legal profession. Judicial independence is thus critical to protect fundamental rights and also for commerce. One of the key features which explains Hong Kong's great success as a seat of arbitration is not just the excellent arbitral institutions we have, the regular updating of the arbitration ordinance, but also the quality and independence of our courts. Arbitration does not exist in a vacuum. Applications to set aside awards and for leave to enforce awards are dealt with by the courts of the arbitral seat, and it is fundamental that these courts are and are seen to be both efficient and independent. In a recent report by the International Bar Association on the social and economic impact of the legal profession, the authors concluded that the strong relationship between the rule of law and economic growth is also backed by empirical evidence. The rule of law is strongly linked with GDP per capita across the globe. A 1-point increase in the rule of law index brings a 0.82% increase in GDP. By building and maintaining the rule of law, legal professionals help create the foundations for economic growth. The rule of law serves the economy, which in turn reinforces the rule of law. In the United Nations General Assembly's declaration of the high-level meeting on the rule of law, it was noted that the rule of law and development are strongly interrelated and mutually reinforcing, that the advancement of the rule of law at the national and international levels is essential for sustained and inclusive economic growth, sustainable development, the eradication of poverty and hunger, and the full realization of all human rights and fundamental freedoms, including the right to development, all of which, in turn, reinforce the rule of law. In summary, the stronger our rule of law, the more prosperous and the more resilient and stable our society will be. Lord Chief Justice Hewitt, in his judgment in the Queen and Sussex Justices ex parte McCarthy, famously held, it is not merely of some importance, but is of fundamental importance that justice should not only be done, but should be manifestly and undoubtedly seen to be done. This dictum is generally well known, if not amongst members of the public, certainly amongst lawyers and law students. Why does perception matter? It is obvious that if parties are reasonably left with a doubt about the impartiality of the court or tribunal, this will have an impact on confidence in its decision. The link between perceptions and reality is borne out by studies on sociology and human behavior. Mr. W.I. Thomas, an American sociologist, set forth a theorem in the field of social science to the effect that if men define situations are real, they are real in their consequences. This is in very broad sense akin to what is sometimes called a self-fulfilling prophecy. Other academics have looked at bank runs through the prism of the Thomas theorem, where rumors of insolvency, once believed by enough depositors, might result in the insolvency of a bank. But for the rumor, the bank would have operated just normally. In short, unlike hard sciences, the perception of the public on certain economic and societal matters affects their reality. Last year, my predecessor, Mr. Victor Dawes SC, rightly highlighted the importance of how individuals and businesses perceive the exercise of rights by individuals and the state. It is important for all actors in Hong Kong to take into account this aspect of their decision-making on such perceptions, which may unwittingly and unintentionally impact on the reality. For its part, the Hong Kong Bar will continue to speak up on matters which relate to the rule of law, judicial independence, and the independence of the legal professions. This is in the Bar's objects and is in our DNA. The Bar is an independent legal profession made up of practitioners who operate independently. This, together with the cab rank rule, which exists only for barristers, explains why, despite our size, we have been able to punch above our weight. One example is our position on matters which relate to the constitutional right to legal representation under Article 35 of the Basic Law. Last year, we expressed our views concerning the amendment to the prison rules. We will also speak out here and abroad when our judiciary is unfairly criticised. This is the right thing to do. Mistaken perceptions regarding our judiciary are detrimental to Hong Kong's legal system and its people. As Mr. Kumar Ramanathan SC said at the opening of the legal year in 2013, the Bar will actively participate in defending judges and the courts from unwarranted attacks. The reality today is that the judiciary is being targeted increasingly for specific case rulings. We have seen from recent events that this is relevant more than ever. The Bar is confident that our judges are apolitical and will consider nothing except the law and the evidence. To criticize a ruling on the simple basis that one doesn't like the outcome is both unfair and does nothing to promote the rule of law. I would like to take this opportunity to thank two individuals who've served the Bar Council with dedication and will be taking what I hope is only a temporary but a well-deserved break. Mr. Derek Chan SC has not only been a high flyer in his criminal practice from day one, but also someone who has always served the Bar and our legal system, both as a council member and as a vice chairman for 3 terms. I would also like to thank Mr. Eugene Yim, who has conscientiously served as our deputy and later secretary and treasurer for a combined 6-year term with dedication and fervent ardor for our values. But for the selfless dedication of many of our members, our mission would not be possible. It remains for me to wish everyone a healthy and happy Year of the Horse.
Good afternoon, Chief Justice, Secretary for Justice, Chairman of the Bar, members of the judiciary, members of the legal profession, distinguished guests, both local and overseas, ladies and gentlemen. Last year, at the opening of legal year, I spoke of a new era for our city and our profession, an era that calls on us to educate, to think big, to uphold our independence, to inspire, and to nurture talent. This year, I return to the same journey with a sharper focus: professionalism, the lodestar that sustains public confidence, trust, strengthens institutions, and enables Hong Kong to serve as a trusted bridge between China and the world. Professionalism begins with fidelity to our constitutional order and the rule of law, which includes judicial independence, due process, equality before the law, and reasoned adjudication. Under one country, 2 systems, Hong Kong remains China's only common law jurisdiction and the world's truly English-Chinese bilingual common law community. This is not just a dual heritage. It is our competitive edge, reflected in advocacy, cross-border transactions, disputes resolution, and the translation of complex standards across systems. Hong Kong's legal profession is recognized globally for its accepting standards and unwavering commitment to the rule of law and judicial independence. The basic law protects these bedrock principles with Article 85 enshrining judicial independence to ensure cases are decided by law, evidence, and proper procedure. As president of the Law Society, I am proud that for over a century, we have safeguarded professional standards through admission, practice regulation, and discipline, while nurturing talent and advancing access to justice, thereby sustaining public trust in our courts and outcomes. The practice of law is not merely a business. It is a public service rooted in the community's trust that justice will prevail. Our judges deserve our highest respect for their unwavering, selfless commitment to adjudicate strictly in accordance with law, undeterred by unfounded criticism or external pressure. Day after day, they carry demanding caseloads, write carefully reasoned judgments, and uphold due process with impartiality and integrity. Rather than the executive or legislative branches, courts bear the ultimate responsibility for deciding cases according to law and proper procedure. That responsibility is discharged by judges who constantly put duty above self. As legal professionals, we must remember that the practice of law is a public service. Professionalism, manifested in integrity, objectivity, diligence, and respect, sustains the community's confidence in the administration of justice. Public service, not profit, defines our profession. Professionalism is not merely an aspiration. It is a concrete standard upheld by law and regulatory bodies. The Law Society's statutory role is to oversee the conduct of law firms and solicitors, maintaining the highest standards through rigorous admission, practice, and disciplinary processes. In the judgment of a solicitor and the Law Society of Hong Kong, the Court of Appeal reaffirmed Sir Thomas Bingham, Master of Laws' formulation in Bolton and Law Society that lawyers must discharge their duties with integrity, probity, and complete trustworthiness. And failures in this respect may warrant severe sanctions to protect the public and preserve confidence in the profession. The judgment emphasized that sanctions serve not as punishment, but to protect the public and uphold the profession's reputation, which outweighs individuals' interests. This case clearly underscores that professionalism and integrity are not optional. They are foundational to public trust and to the rule of law. History teaches that the true measure of a profession is revealed not in moments of ease, but in times of adversity. When our city faces uncertainty, when our institutions are tested, and when the rule of law is challenged. The public expects the legal profession to step forward, to lead, to defend, and to inspire confidence. In the heartbreaking typo fire at Rainfong Court last November, the Law Society mobilized at once, launching an emergency-free legal helpline where volunteer solicitors provided guidance on personal injuries, wills and probate, insurance, civil litigation, and building management. We also set up on-site service counters across districts, enabling face-to-face support for families navigating laws and uncertainty. The quiet reliability of our members, including many young practitioners, exemplified professionalism under pressure. During our visit and tribute to the affected at the site, we witnessed citizens from all corners of Hong Kong queuing in solidarity, paying their respects with dignity and order, which was profoundly moving. It is a testament to the compassion and resilience that define our city. The orderly seeking of assistance by the unfortunate ones and the systemic support of the community strongly reflect that in times of adversity, the rule of law is a genuine safeguard of our society. Moments like this remind us, in the most challenging times, professionalism ensures the role of the legal profession is enshrined, so that the law is not only argued in courtrooms, but also brings clarity, support, and hope to communities in need. Our nation is embarking on a new chapter. The 4 plenary sessions of the 20th Central Committee of the Communist Party of China deliberated and adopted the recommendations for formulating the 15th five-year plan, setting strategic plans for our country's development over the next 5 years, including important plans to support Hong Kong's development, painting a brighter future for our city. Under the recommendations, Hong Kong's strategic position has been defined to consolidate and enhance our status as an international financial, shipping, and trade center, and to build an international innovation and technology center. Our city is specifically called on to better leverage its role as a two-way opening bridge, fully strengthening its function as super connector and super value adder, so that it shall become a major channel hub for attracting external resources and a key platform for Chinese mainland enterprise to go global, thereby assisting the country's high-level opening up. This strategic vision aligns with commentary that urges Hong Kong to proactively connect with the 15th five-year plan, embracing a hub plus engine role, connecting domestic and international markets, empowering innovation, and serving national modernization with new quality productive force, ranging from green finance and digital trade to smarter professional services. For our legal profession, professionalism ensures reforms are grounded in clear drafting, precise interpretation, and impartial administration. By upholding these standards, we reinforce institutional trust and sustain Hong Kong's roles as a beacon of Hong Kong excellence and a bridge between systems, contributing to the high-quality development envisioned in the 4 plenary sessions' recommendation for Hong Kong's long-term prosperity and stability. Professionalism also means preparedness, building resilient systems that protect the public, enable commerce, and responsibly harness technology. For over 35 years, our professional indemnity scheme has safeguarded both the profession and the public. Together with a robust anti-money laundering regulatory regime, we have proven the credibility of self-regulations that is essential to independence of the profession and the rule of law. The Law Society has prepared for the law tech and AI with foresight. As early as 2009, we introduced principles in the Hong Kong Solicitor Guide to Professional Conduct to govern the use of technology by solicitors, ensuring compliance with legal and ethical requirements. In 2024, we published a position paper on the impact of AI on the legal profession, highlighting the need for timely and proactive measures to guide AI adoptions for the benefit of our profession and the public. Most recently, we launched a brand new mobile application in last December, which represents a significant step forward in member engagement by offering a consolidated platform of features and services. Together, these initiatives reflect responsible innovation anchored in professional standards. While yearly indicators may shift, the long arc shows Hong Kong's legal system remains robust. The Real Justice Project Index placed Hong Kong high regionally and strong in absence of corruption and regulatory enforcement, reflecting the integrity in our systems and the diligence in our practice. These are not statistics to rest upon, but standards to surpass. As reforms advance and international ties deepen, professionalism will remain the currency that keeps trust high in courtrooms, in boardrooms, and across borders. As I draw this address to a close, it is my distinct honor to announce that the Law Society will soon embark on a new and momentous chapter with the opening of our new office premises in the second quarter of this year. Founded in 1907, the Law Society has walked alongside Hong Kong for 119 years, steadfastly committed to serving the public good and upholding the highest ideals of professionalism. In our long history, we have acquired our own premises only choice. First, in 1998, when our membership numbered around 4,500. And now, as we prepare to serve over 13,500 dedicated professionals. This relocation is not merely a change of address, but a reflection of our collective journey, our growth, and our enduring responsibility to the community. It is a humble milestone, reminding us that our true purpose lies in serving alongside Hong Kong, supporting its people, and advancing the rule of law for the benefit of all. Let us remember, professionalism is both our privilege and responsibility. It is how we sustain respect for our judges, whose selfless professionalism fortifies the rule of law, how we dignify our clients, and how we preserve trust of the public. It is also how Hong Kong's common law tradition contributes to China's modernization, advancing reform through law with integrity and confidence. May I wish you all a very happy New Year and good health. Thank you.
主禮人士即將離場，請各位繼續安坐，至主禮人士完全離場。Please remain seated until the whole official party has exited from the hall. 主禮人士即將離場，請各位繼續安坐，至主禮人士完全離場。
主禮人士已經離場，多謝各位。The official party has exited. Thank you. 主禮人士已經離場，多謝各位。
終審法院首席法官會做一個開場發言，然後回答大家嘅提問嘅。司機可以。
好，唔該晒。首先好歡迎大家記者、傳媒嘅朋友嚟到呢個記者招待會啦。咁咧就各位嘅記者朋友嘅問題嘅。Now I would like to welcome all to this media session. As practiced in the past, I will first do, for the benefit of the media in Chinese, a summary of the speech I on the floor. Now, 今日咧就我喺今日嘅演辭裏邊咧有兩個重點。第一個咧就重申一些法治同埋司法獨立嘅重要基本原則。第二咧就係探討司法機關並且咧行政同埋立法機關喺保障權利方面嘅不同嘅憲制角色。首先咧，我強調香港嘅基本法一般嘅法律同埋咧有關同埋證據同埋法律嘅論點，而非任何外在嘅因素或者公眾嘅壓力。我哋嘅法官必須秉持專業，謹守司法誓言，公平公正咁執行司法嘅工作。除咗極少數明確界定嘅例外情況之外，所有刑事審訊均喺公開法庭舉行，按照已確立嘅刑事訴訟程序同埋證據規則而進行嘅。控方係負有舉證嘅責任，需要喺毫無合理疑點下證明被告人有罪。被告人有權選擇作供，為自己辯護，就法庭嘅裁決亦可以按適用嘅程序提出上訴或者覆核。法治其中一個基本嘅信念係冇人能夠凌駕法律之上。真誠致力維護法治嘅人呢，必定同時全力支持法庭按照確立嘅法律程序執行司法工作，而不受干預。針對香港法官實施制裁呢啲威脅呢，係企圖干預司法獨立、破壞公義嘅手段，不容於文明法治社會。跟住落嚟咧，喺我嘅演辭裏邊咧，就講到第二個題目，就係關於司法機構同埋行政機關、立法機關喺保障權利方面，大家唔同嘅憲制角色。法院嘅憲制職能係獨立進行審判，將法律嘅原則應用於喺案件嘅案情，然後作出有理可據嘅裁決。如果證明政府確有侵權或者未能保障某項權利嘅情況，法庭必須如實裁決，並且考慮係咪給予濟助或者頒發何等嘅濟助。喺一些案件，法庭只會作出聲明，就係對當事人嘅權利、義務或者法律地位或者其他相關嘅事項作出關於法律立場嘅正式陳述。唔論係乜嘢情況，法庭嘅判決咧必須附有清晰嘅理據，而且法庭會給予政府空間，根據法治嘅精神同埋良好管治嘅原則，決定點樣最穩妥嘅履行佢嘅憲法或者公法嘅責任。法庭藉應用法律嚟實施司法，既不尋求管治，亦不立法。香港嘅憲制源於憲法嘅基本法，行使權利。根據基本法，終審法院嘅詮釋對所有人都有約束力。尊重終審法院嘅判決，其實就係尊重基本法。 喺合乎基本法同埋基本法所訂定嘅法律範圍之內咧，行政機關負責喺有需要嘅時候提出立法建議，而立法會呢則負責考慮同埋制定佢認為合適嘅法律。呢個設計形成憲制嘅分工，行政、立法同埋司法機關按自身嘅憲制角色各司其職。最後呢，司法機構對去年11月發生嘅大埔宏福苑火災深感哀痛。司法機構已經宣布咗一系列嘅措施，加快和優先處理火災產生嘅法律嘅程序。我哋已經成立咗一個工作小組，監督各級法院處理同事故有關嘅案件。司法機構亦已經設立支援隊伍，協助處理遺產承辦事宜嘅。喺我回答傳媒嘅問題之先呢，有一兩樣嘢要講一講嘅。咁好明顯啊，大家都係關注嘅，因為亦都我喺個演詞度提到啦，有最近嘅黎智英一案嘅。但係我亦都嗰度講過啦，嗰個案件呢仲係審理緊，甚至無判刑呢都係未判決嘅。咁所以咧就係絕對咧，我唔適合咧喺呢度對嗰個案件作出任何嘅評論。第二樣嘢咧就係、是、我喺個演詞度提到司法機構同埋行政同埋立法機構對於維護權利特別基本權利嘅唔同嘅角色。咁能夠理解嘅，好多人會聽到呢啲題目嘅時候，會諗到一啲個別嘅具體題目，譬如話係同性伴侶嘅登記關係嘅登記呢啲方面嘅題目，相信咧亦都傳媒係有啲興趣嘅。但係同樣啦，呢啲個別具體嘅案件，甚至乎咧呢方面嘅題目咧，將來都可能仲有官司訴諸法庭或者法庭需要處理嘅咧，亦都係好明顯咧，就我唔適合咧係就呢啲具體嘅題目咧作出任何嘅回答啦。所以首先咧講咗先可。Now I've just said in Chinese for the benefit of those working for English media that there are two topics that I would not comment on, despite understandably there may be some interest in them. The first is in relation to the trial of Mrs. Jimmy Lai and the other defendants. Now, the proceedings are still ongoing, and in fact, sentencing has not been completed, so it would not be appropriate for me to answer any questions in relation to that particular case. It would not be appropriate for me to do so. Now, the second topic that I would not reply to is in relation to the question specific items such as same-sex relationship or the registration regime about same-sex relationship. Even though I have touched on or I have mentioned in my speech today about the respective roles of the judiciary, the legislature and the executive in relation to the protection of rights. Understandably, some may immediately think of topics such as same-sex relationship registration and so forth, and the government's introduction of a bill before the large legislature for the enactment of a registration regime. Now, because this concerns specific cases, and because this type of topic may still come back to the courts in litigation. So again, it would not be appropriate for me to answer questions in relation to the topic as such. So with those remarks, I will now take questions from the media. 我而家就開始。
或者我講一講先，咁就有意提問嘅記者請舉手啦。咁我會示意邊一位提問嘅。咁同時會遞個咪俾你哋啦。咁請講出你代表嘅傳媒機構。咁每次提問係最多3條嘅，大家。後邊我右手邊度第2行第4位記者。你好，有
線係首先想問下，即係有關法官人手短缺啦，因為都知道上年行政署透露，其實高院法官有8個空缺嘅，咁加上之後可能有法官退休，咁其實未來有啲咩部署咧？咁同埋揾翻相關資歷嘅法官，其實係咪有困難咧？另外第二條就係、即係雖然你都講到話同性伴侶登記草案就唔方便個別咁樣即係個別案件咁評論啦，但係其實而家寬限期已經過咗幾個月，咁但係政府同立法會仲未有一個替代方案啦。咁你覺得即係你作為終審法院首席法官，覺得而家三權未有一個共識嘅情況之下，其實可以點樣協調咧？咁同埋行政嘅手段去解決，其實係咪一個理想嘅方法咧？唔該。
多謝呢個記者朋友嘅問題啦。第一，你講咗個都好多時傳媒啊或者睇報道咧都關心嘅問題，司法人手嘅問題。咁咧呢個係一個好嘅問題嚟嘅。但係司法機構好似所有機構一樣，從來都有人會入職啦，有人會升職啦，有人會退休或者甚至乎提早退休，明白嘅呢方面咧就係好正常嘅事情。喺司法機構嚟講咧，就我哋咧就係一定係絕對各級嘅法院咧，我哋都會不時嘅去招聘我哋嘅人手去填補咧，因為升遷啦、升咗職啦或者退休嘅同事咧流出嚟嘅空缺嘅，包括我哋嘅高等法院嘅法官在內嘅，咁你會留意到咧，實際咧我哋有個統計嘅，我都有同事俾個數字我哋咧。由2023年到2025年咧，我哋實際各級嘅法院咧都委任咗24個法官咁多嘅。就算喺你正話問到嘅高等法院啦，包括原訟法庭同埋上訴法庭咧，我哋都委任咗7個法官咁多嘅。當有外邊嘅執業嘅法律界人士啦，去加入我哋嘅法官嘅行列啦，亦都我哋有內部晉升嘅。喺呢方面咧，我係有一個合理嘅樂觀嘅。我知道咧，我哋內部嘅人才咧，亦都不斷嘅有培養到出嚟啦。亦都我哋知道咧，外邊咧亦都有志之士咧，係願意咧加入司法機構咧當法官啊，包括呢個高等法院嘅法官嘅。咁另外當然人手，咁大家都亦都諗到人手會唔會影響你嗰個工作效率？就明白嘅，從來做一個機構嘅主管都係只要財政容許到嘅話咧，多啲人手梗係永遠都歡迎嘅。但係我哋嘅工作量亦都係唔細嘅。但係咧，我哋咁多年嚟咧，亦都採取咧唔同嘅方法咧去處理我哋嘅工作量嘅，包括咧我哋係招聘啦，又招聘人手啦，包括有法官嘅延任啦，亦都有包括咧法官嘅再委任啦，包括咧早幾年2019年嗰個延長嗰個退休年齡啦，亦都有包括咧我哋當然想請出邊嘅好嘅法律執業人士嚟參加我哋嘅工作啦，但係你都明白咧，越好嘅出邊嘅待遇一定係好高嘅，咁我哋亦都有咧改善同埋咧我哋嘅檢討我哋嘅法官嘅薪酬成個嘅一個 package 啊，英文係講下嗰個薪酬嘅一個嘅嘢咧方面咧，令到佢點樣吸引啲啊，令到點樣可以落地啲對出面嘅執業嘅人士咧有吸引力啦。另外我哋亦都有一啲站位嘅委任啦，呢方面都幫助我哋好多工作嘅。咁如果或者等有傳媒有興趣問到嘅，譬如嗰個酷刑嘅申請方面咧，過去嗰年咧，我哋因為我哋有個新嘅制度咧，都喺呢方面嘅案件咧處理到多咗嘅。但係呢啲我唔太多講啦，或者等有問題問先回答啦。但無論如何，人手同埋工作量咧，我哋都係有好高嘅落到去力咧去處理呢方面嘅。我係相信咧呢方面係我哋可以咧係完全咧處理得到嘅。呢個第一個問題。第二個問題咧就係嗰個同性伴侶嗰個登記嗰方面啦，明白㗎啦。咁大家都明白啦，你又明白我明白你啦，你都知道我咧就唔能夠講個案件嘅，因為呢個案件或者你正話特別提到嗰個案件裏邊有嗰個suspension 啊，係咪暫停嗰個法庭嘅聲明2年。咁呢個你直情問緊嗰單案裏面嘅情況，過咗2年啦點算？你直情問緊嗰單案，咁好明顯咧，我唔能夠回答你嘅。亦都講過啦，呢類嘅案件間中咧 咧，仲有喺法庭有新嘅案件啦，或者有案件或者類似嘅案件，仍然喺我哋法庭嘅系統裏邊，我亦都唔能夠回答你啦。我想講嘅嘢咧，實際咧，今日我已經喺嗰個我嘅演詞裏邊咧，都好詳盡啊，花咗一半篇幅以上咧講法庭嘅角色啦，講行政機關嘅角色啦，立法機關嘅角色啦，呢個係我哋嘅憲制秩序裏邊嘅設計啦。就算暫時嚟講，或者個別嘅情況未必係行政立法或者點樣，佢哋有一定嘅睇法完全相同嘅時候咧，我哋嘅憲制秩序嘅設計，我就係想講咧係好好嘅，唔會係停滯不前嘅，未必係啲嘢100%咁完美無瑕。咁呢個世界都好少嘢係完美無瑕嘅啦，但係咧唔等於係冇進展冇進步嘅。咁喺呢方面咧就點樣回答咗呢位記者朋友嘅提問啦。
喺我左手邊最第3行嗰位女記者。
你好啊，香港人嘅首先想問下，即係都見到頭先提到黃福苑嗰邊都成立咗一個專責嘅工作小組啦。咁都想問下，因為都見有宣布到而家都1個月啦，都想知道嗰個進度其實係點咧？係咪已經開始處理緊一啲案件咧？會唔會有一個數字提供？即係可能而家處理緊幾多案件咧？同埋都見到即係可能有啲災民都擔心會唔會好難追討，或者即係要經過個好長嘅法律程序啦。即係覺得可以點樣挽回翻即係佢哋嘅信心咧？另外就係想問翻之前終審法院有海外法官離任啦，咁想問下其實而家係咪都即係仍然都進行一啲招聘咧？同埋即係其實招聘係咪都出現一啲困難咧？另外想問其實會唔會考慮委任即係新加坡啊、印度等等呢啲即係其他普通法地區嘅法官咧？另外同埋即係都見到之前有人就話即係可能司法機構其實已經有足夠嘅專業啦，質疑其實海外法官係咪都仍然有即係實質嘅需要？你又點樣睇呢啲説法咧？唔該。
好啊，亦都多謝呢位記者朋友嘅問題啦。大埔嘅火災係好不幸嘅事件咧，我哋都好唔開心嘅。但係好欣喜嘅咧，就係成個社會，無論係官方嘅、民間嘅、個人嘅、團體嘅，包括我哋司法機構在內咧，都要盡我哋一分嘅綿力，幫助呢啲咁不幸嘅家庭同埋受影響嘅人士，同埋整個嘅大埔成個社區啦，你可以咁講。有時你駕車冇啊，你就算唔係住喺嗰度咧，見到呢個時候咧，個心就好難過。咁呢個係好能夠明白嘅。咁至於話我哋司法機構咧，我哋盡嘅綿力咧，我正話都講過啦。我哋之前咧亦都出過個新聞嘅稿咧，講我哋有啲乜嘢嘢可以做嘅。你都特別問到咧有咩案件啊咁樣咧，你明白得訴訟咧程序咧就點都就算點樣快速咧，佢一定嘅法律嘅程序嘅係程序咧係保障公義嘅，係咪啊？嘅時候咧，亦都當然唔可以貿然嘅呢個去產生任何法律嘅程序啦，因為一定要有法律嘅意見，然後有個法律嘅根基先可以產生呢啲法律嘅程序。當然攞資料啊，或者搜集個證據啊、事實啊，或者甚至冇有啲人要攞法律援助啊、請律師啊，呢啲都係需時嘅。無論社會各方面，包括法律界，包括法律援助處或者律師啊、大律師方面去喺政府啊幾想幫助你，都有一定嘅時間需要嘅。咁快嚟講，只係大家都報道啦，睇過啦，就係嗰啲嗰個立案法團嗰個處理啫，係喺我哋土地審裁處係有一宗嘅司法嘅程序，嗰個都係處理咗嘅。我想強調，我哋係司法機構嗰個我哋嗰個措施呢係一啲行政措施，但係行政措施從來都唔可以凌駕法律嘅程序嘅。所以行政措施，無論首席法官喺佢行政嘅角色裏邊點樣宣佈嘅時候咧，都唔可以干預我哋法官，包括土地審裁處嘅司法人員，佢哋行使司法嘅職能或者佢司法嘅酌情權嘅，係兩回事嚟㗎。呢個實際係一個大嘅原則嚟㗎。呢個佢哋當佢哋做法官或者司法人員審緊案，行使法律俾佢哋權力，包括嗰個佢哋嘅司法酌情權嘅時候咧，係不容任何干預，不容外面干預，亦都不容咧首席法官作行政方面無論乜嘢嘅行政嘅 嘢嘅干預嘅。咁所以喺呢方面咧，佢哋有一定嘅程序必須要跟，佢要考慮晒所有法律上應該同埋合乎道理應該考慮嘅原因之下，行使呢條法律嘅權利去決定實質嘅結果或者一啲程序方面嘅嘢。呢個咧，我哋只不過係喺排期方面，如果有啲案件嘅時候，排期案件人手調配呢方面係比較優先。所以真正嘅法律程序嘅牽涉訴訟嘅案件咧，就係嗰單啦。但係非法律性非訴訟性嘅程序，就譬如話遺產嘅申領啊，或者遺產嘅代表啊方面咧，已經有呢啲嘅個案㗎啦。有嘅個案嘅時候咧，我哋都係全部都係好似我哋嗰個行政宣佈咁咧，都係豁免咗個申辦遺產方面嘅費用嘅，亦都我哋出咗一啲嘅所謂死亡嘅認證嗰個證明書咧，亦都有。如果我記得個數目咧，我呢個未必係準確啦。完咗之後，如果大家真係需要個實際嘅數字，就可以問我哋司法機構嘅發言人嗰方面，我哋好樂意提供嘅，應該係幾十個以上嘅。但我可能錯嘅，呢個咧，我哋等一陣可以攞翻個準確嘅數字。所以所有呢啲嘢，如果我哋行政方面可以調配，亦都對其他嘅法律使用者唔係太過不便嘅話，當然我哋亦都要顧慮其他人嘅利益嘅時候咧，我哋都會盡量去方便嘅。有法律嘅條文規定嘅，一定要按法律去做事。呢方面就係我哋處理嘅嘢啦。另外一方面嘅題目咧，就係嗰個海外非常任法官呢個終審法院嘅法官呢方面嘅問題啦。嗱，嗰個詳細嘅嘢咧，同舊年我講，因為舊年個其中一個重要嘅題目就係講海外非常任法官方面。咁如果你有興趣，你睇翻我舊年嘅發言咧，就比較清楚啲。嗱，答翻你嗰幾樣嘢，第一啱嘅，我哋係持續嘅，按住我哋需要同埋有冇合適嘅海外嘅可以招聘嘅海外非常任法官咧，繼續咧係希望招聘到海外非常任法官。咁我好開心地咧，舊年咧2025年咧，正話都有演辭裏邊有講之前提過咧，我哋有Sir William Young咧，佢係紐西蘭退休嘅。最高法院啊 Supreme Court， 佢哋 Supreme Court 即係等於我哋嘅終審法院咁最高嘅法院咧，係退咗休之後加入咗我哋終審法院非常任法官嘅行列嘅。咁另外你問到啦，會唔會喺其他嘅地區包括新加坡、印度啊，或者其他嘅普通法系嘅司法管轄區裏邊招聘呢個非常任嘅海外法官咧？嗱，呢個問題問得好啊！實際個問題咧，我哋招聘海外嘅非常任法官嘅時候咧，個考慮點唔係佢由邊個國家嚟，唔係佢由邊個司法管轄區嚟，而係考慮佢嘅喺司法領域裏邊，喺普通法裏邊嘅聲望啦，佢嘅履歷啦，佢嘅經驗啦，佢嘅專長啦，亦都考慮佢嚟自佢嗰個司法制度咧，雖然同樣普通法咧，同我哋香港嗰個係咪接近咧？係咪？你要明白普通法系裏邊咧有好多唔同嘅管轄區嘅，佢個制度咧都有啲唔同嘅。咁我哋一定要揾啲咧同我哋相近嘅制度嘅司法普通法嘅司法管轄區嘅法官咧嚟邀請嚟做我哋嘅海外非常任法官啦。咁亦都要對佢哋，所以亦都我哋要熟悉佢哋嘅制度啦，或者熟悉個法官本人啊，先比較容易啲邀請嘅。從來咧挑戰都有嘅，特別咧地緣政治嘅關係咧，好似我舊年嘅演辭講咧，一定有啲影響嘅。我舊年我記得我都講過啦，有啲咧我哋根本私人上識得佢咧，佢根本好中意我哋香港嘅，佢甚至乎好想嚟嘅，覺得我哋香港嘅制度好好，啲法律係好英文嚟講好 sophisticated， 實際咧係好多方面咧有進步對成個普通法嘅體系嚟講咧有貢獻嘅，好想嚟嘅。但係礙於佢哋本地嚟講，可能地緣政治啊，或者一啲嘅睇法啊、傳媒嘅意見啊，似乎咧就係明白嘅，能夠理解，我哋都尊重佢哋啦。似乎有啲呢啲嘅朋友都覺得可能要諗真啲先啊，或者要避一避啊，咁能夠理解嘅。佢冇責任嚟香港做法官嘅。但係如果佢嚟嘅話，好似Sir William Young咁，或者我哋實際由2023年每年有一個新嘅海外非常法官嚟啦，2023有一個啦，Kim 法官啦， 24有柯索法官咧，2025有 William 法官咧嚟嘅時候咧，我哋都好感謝佢哋。實際喺啲外國務處有時間中都有啲對佢哋好唔公道嘅批評咧，都嚟到我哋香港幫助我哋香港嘅審案，我哋好欣賞嘅工作啦。咁你亦都係問到係咪仲需要海外非常法官啊？我舊年都詳細講咗啦，咁我唔想再花大家咁多時間講啦。係當然我哋有本地係人才輩出嘅，呢過去嗰20幾年，由97到而家，同97嗰陣時要設計呢個非常法官個背景係完全唔同啦。香港而家係好多好叻嘅，實際係好多好叻嘅專業嘅法律界人士。你有時打聽下問下出邊嗰啲法律界人士啦，你喺邊度讀書㗎？你讀書嗰陣時考第幾㗎？你喺外國點㗎？你喺香港做啲乜嘢案㗎？或者你睇下佢哋上庭嗰時，邊個對邊個？有時一方面係外國嚟嘅資深係御用大律師啦，有啲係香港嘅資深大律師，甚至乎係大律師，或者我哋一啲嘅有訟辯權嘅高等訟辯權嘅律師都好啦，佢哋係完全係冇分別嘅，可以對方對晒呢個海外嚟嘅律師完全頂得住嘅，拍得住嘅，完全唔會失色，任何失色嘅。你睇到我哋香港嘅法律水準係好高，對呢方面但我哋舊年解釋過咧，但係仍然有海外嘅非常任法官咧，我哋係對同成個普通法我哋嘅交流保持我哋香港嘅普通法嘅發展同外國嘅普通法嘅發展唔好脫節，甚至銜接，亦都係互相嘅借鏡參考，互相嘅學習啦，可以咁講，我哋可以咁講嘅時候好有幫助。當然亦都好實際地，國際投資者見到香港嘅最高嘅法院有外國嘅頂尖嘅法官喺度坐嘅時候咧，好明白嘅，能夠理解嘅，佢會覺得安心，會覺得有信心，呢啲非常之好嘅，係雙贏嘅情況，我哋係完全冇問題嘅。所以呢個制度咧係非常好嘅制度，我哋亦都致力維持嘅。
第一行嘅男士記者。
Three questions from AFP. Mr. Chief Justice, 1 year ago in this same room, you were asked about the sham CFA ruling, and you answered in specific terms. But in your disclaimer just now, you said you cannot comment because this type of topic may still come back. Can you clarify why you were in a position to comment last year, but you are not in a position to comment today? My second question is, in the sham CK case, the CFA declared that the government had a positive obligation to establish an alternative framework for legal recognition of same-sex partnerships. Putting aside any policy discussion, purely as a matter of law, at this moment, has that positive obligation been fulfilled? My third question is, in your speech today, you mentioned the possibility of foreign sanctions against judges. On a practical level, how do you think that at-risk judges can prepare themselves, and what will the judiciary do to support them on a practical sense if the sanctions do appear?
No, thank you very much for the questions. Now, I must have got a very short memory now. I really cannot remember my commenting specifically on this sham case last year. But what I can say is that I would not comment on any particular case, including the sham case. Now, I've already said that this topic may come back to the court again in future litigations, and it would not be appropriate for me to comment on the case as such. Now, if I had said anything about the sham case last year, well, what has been said has already been said. I'm not going to add to what I am supposed to have said last year. So please forgive me for this. I do think that it will not be appropriate for me to comment on a particular case. Now, as regards the question as to whether the government in the sham case or in accordance with the CFA's holding that that the government has fulfilled its positive obligation to protect the rights to privacy. Against that would involve my going into the holding in the sham case, which, as I tried to explain, I would not do. Now, as regards foreign sanctions and steps that may have been taken to prepare those judges who are at risk of being sanctioned. Now, can I reiterate this? Now, threats of sanction are totally unacceptable to any judicial system, and it is wholly unacceptable to us. It is a direct affront to the rule of law. So now, as regards the judges who have been named or who have been judges who have been named as targets for potential sanctioning. Now, this is wholly unfair to these colleagues of ours who have only been performing their duties in accordance with their judicial oath. Now, your questions relates to the practical steps that may have been taken in protection of these colleagues. Now, given these threats of sanction, whatever steps that may have been taken would have to remain confidential and not be reviewed in the public domain, lest measures will be taken to counter these measures. Now, my not revealing any details about these possible measures is to achieve one purpose only, to protect our judges against any possible sanctions that may be imposed. Of course, I hope that these sanctions, threats of sanctions, will never materialize. Now, but all I wish to repeat is that in a civilized society like Hong Kong, which is governed by the rule of law, threats of sanctions are wholly unacceptable. Thank you.
喺左手邊第三行嗰位女表姐。
TVB 嘅，首先想繼續問翻關於即係海外法官啦，就同1年前一樣咧，個數目都係保持喺6位啦。咁頭先都有講過係會持續繼續進行招聘工作嘅，咁係咪真係反映招聘上面遇到一啲困難呢？咁第二就關於即係有海外常任法官訪問到提到話離任係因為國安法啦，有冇其他法官喺即係招聘或者延任工作嘅時候提出相關同樣嘅問題呢？咁而呢啲考慮有冇話影響到相關嘅招聘或者延任工作？第三就係頭先演辭都有提及過啦，即係海外都好關注香港嘅國安案件，咁呢啲對香港嘅司法工作有冇話帶嚟啲咩挑戰呢？
多謝呢位記者朋友提問啦。我想強調呢，我哋終審法院嘅司法工作呢，實際過去嘅案件數量呢，呢幾年呢好穩定嘅。咁我哋呢，實際呢，而家有6位海外嘅非常任法官，亦都有4位本地嘅非常任法官呢，再加埋我哋常任法官呢有3個，再加埋首席法官呢，我哋總共有14位法官嘅。我哋每一次咧開庭需要5位，人手方面咧係足夠嘅。我諗我可能1-2年前都提過下，有時咧我哋以前有啲時間咧，因為有海外非常法官咧，但係因為我哋人數嘅問題啊，即係有時一屆係3年啊，只能夠請到佢嚟1次啦，有時都唔係幾好意思嘅。咁咧嘅時候咧，就反而咧就覺得，喂，你請我嚟做非常法官，你要3年啫，請我嚟1次啊咁樣樣，我哋有時都唔好意思。而家6個海外嘅非常法官咧，人手係絕對足夠，平均大約係年半到嚟1次到啦，1次咧嚟1個月審喎。所以如果一任3年嘅話咧，大約嚟2次到，咁我哋嘅人手係好足夠嘅。 既然咧人手足夠方面咧，我哋咧冇迫切嘅壓力話需要增加呢方面嘅人手，但係咧話又説回來咧，永遠如果有適合嘅好嘅頂尖兒嘅法官，海外嘅法官，佢係願意考慮俾我哋嘅委任嘅話咧，我哋都好願意咧聯絡佢哋，希望咧佢哋咧可以嚟到咧我哋香港咧成為我哋嘅非常任法官嘅。你話有冇困難？我舊年都花咗好多篇幅嚟講嘅，正話都有少少提到，明白嘅有困難，純粹咧個困難咧就係一啲地緣政治嘅原因，唔係啲法官唔肯嚟，係咪啊？咁咧我哋都講過啦，我哋接觸過啲法官女仔好中意嚟嘅，咁有啲法官咧識我哋嘅，係嘛？即係嚟過香港好多次，或者佢以前執業嘅時候咧，甚至冇嚟過香港，好明白香港嘅情況。但係礙於咧佢哋本國本地咧有啲嘅壓力嘅時候咧，佢都可能要三思。有嘅呢方面係有呢啲嘅困難，但係唔到一個情況話我哋請唔到。我啱先講過啦，我哋過去嗰3年每年一個咁啦，係嘛？咁當然亦都有人嚟，亦都有人退休，係嘛？有人咧做到80幾歲啦。今日正話亦都提到啦，霍夫曼法官佢90鬆啲歲嘅啦，即係佢仍然啱啱續任咗3年咧，3月佢又嚟啦，佢3月又嚟審幾單案嘅。咁你見到佢咧，你知道咧，佢身體非常之好。咁佢願意嚟就好好啦。咁亦都有人年紀大嘅原因咧退休啦，亦都有啲人咧嫌嚟得耐，因為一次嚟1個月嘅，佢唔同第二啲海外某啲地方，佢叫佢審案有啲根本唔使去嘅，有啲嚟1日咁梗係冇問題啦。我哋嚟1個月嘅，年紀太大嘅時候佢嚟，或者佢配偶唔方便嚟，或者嘅時候去考慮唔接受，亦都有好個別嘅法官亦都有啦。咁亦全部佢因為咧覺得香港嘅國安法佢或者香港嘅審案唔係好似咁啦，佢有佢個人嘅意見，唔想再參與啦。亦都我哋尊重佢個人嘅意見嘅，咁人都有佢自己意見嘅啦，係咪？咁你有啲人同意佢意見，有啲人唔同意意見，有啲人發表呢個意見，有人同意，有人唔同意，有啲人發表好多意見，有啲同意，有啲唔同意，咁亦都可以留意下係咪所有人嘅意見喺本地又好啦，或者佢哋自己本地又好，或者香港大家同意啊，或者唔同意。咁明白嘅人都有唔同意見，但係咧喺呢方面咧，我哋咧係尊重各人嘅唔同意見。但係講翻轉頭，大家最關心我哋中院嘅運作，咁呢個咧我可以同大家保證嘅，呢方面係絕對冇問題㗎。嗱，你另外就問到國安嗰個外地咧關注我哋香港嘅國安嗰啲案件嘅情況啊，有咩影響咧？咁我覺得係基本上係冇影響嘅，即係可能有人好想有影響，但係對我哋嚟講冇影響。嗰啲法官係專業嘅，實際好多時好多人講好多嘢，寫好多嘢，希望或者無論咩原因都好啦，出於真心又好，好意又好，或者佢有自己嘅意圖又好，想影響我哋法官嘅。但係啲法官係即係實際我作為首席法官咧，好開心講，我哋香港啲法官係好專業，你識得佢哋知道，佢哋好專業嘅，佢哋根本就唔會理外邊啲人講嘅嘢，外邊有幾多嘅注視，包括外國嘅情況。咁你話有咩影響？有時甚至乎再極端例子，啱答咗條問題咧，話個威脅制裁嗰啲嘢，就算講咩情況咧，我哋法官咧都係完全唔理嘅，係咪？要你話有制裁咁最好咁判啦，咁判就冇制裁啦。但係你見到啲完全唔係咁，咁你有制裁好冇制裁佢？佢完全都係跟翻法律、證據、案情同埋嗰個案件本身嚟判案，所以呢方面咧，我對我啲同事咧，我係表示得非常之尊敬同埋尊重，多謝亦都感謝佢哋嘅盡忠嘅接受嘅，多謝。
Justice, a question from Reuters. I note your opening remarks about not commenting on said specific cases. But I also note that in your speech earlier, you did make some reference to general legal principles in the handling of all cases. And I just wanted to put a general question to you without sort of going into specifics. But you mentioned that the judges, they'll do their best to shut out external voices. And in recent times, we've had some very prominent international leaders comment on certain cases in Hong Kong, and one in particular raised the notion that perhaps a deal could be reached over a particular defendant in a prominent case. So, just speaking in terms of general legal principles, what response would you make to this notion aired by certain prominent global leaders that somehow they could affect the outcome of judicial proceedings in Hong Kong?
Thank you for this question. Now, thank you for respecting my restrictions in terms of answering questions relating to specific cases. Now, but speaking generally, I've already said that one important tenet of the rule of law is equality before the law. Everyone is equal before the law. So any calls from anybody, no matter how important he or she may be, that a particular defendant facing criminal charges before a court of law should be released prematurely, simply because of the defendant's occupation, connection, or political causes or inclination, would not be right. Not only would that circumvent the judicial process, which is there to determine innocence or guilt in accordance with laws and in accordance with legal procedure. It also strikes at this principle of equality before the law. Think about it this way. How unfair it would be if a defendant happens to know somebody who is powerful, whose voice is listened to by others, and that important person speaks up for you, speaks out for you, asks for your release by the authorities, by the court, and he or she is therefore released. How unfair that would be when you compare with another defendant who's a nobody and who knows nobody of any significance, and there being no one to speak up for him, to speak out for him, to make threats, to offer steals for his or her early release, and therefore he or she remains in the dock to face trial. Maybe he's convicted, maybe he's acquitted. How unfair that society would be. I wouldn't want to live in that society and become the Chief Justice of that society. But fortunately, you and I are not living in such a society. In Hong Kong, we treasure the rule of law. We abide by this most fundamental principle of equality before the law. No matter who you are subject to the law. No matter who is speaking up or speaking out for you or offering dues on your behalf, you are treated equally before the court, and your case will not be dealt with any differently from any other cases that the courts deal with in Hong Kong. And I'm proud to be the Chief Justice of the judicial system of such a society like Hong Kong. Thank you.
呢度第二項嗰位男記者
司長你好，港台嘅提問，頭先喺演辭嘅時候都即係有提到黎智英案啦，咁其實同時都有即係有幾個人提到即係話有啲聲音係要求提早釋放某啲被告，咁呢個做法咧其實就係即係直接衝擊法治核心嘅，咁都明白即係唔能夠即係評論個別案件，咁喺唔評論個別案件嘅情況下，咁你都即係演繹多少少即係點解會有呢一個嘅睇法同埋呢個推論咧？另外就係即係聘任非常任法官嗰度啦，頭先提到即係都即係想繼續招聘，但係而家人手足夠，咁換言之係咪即係可以理解為即係喺未來一段時間即係都會繼續維持6名嘅海外非常任法官嘅數目咧？如果之後日後去招聘嘅時候，除咗頭先提話人工之外，有冇啲其他方法可以游說到佢哋，即係吸引佢哋過嚟香港咧？唔該。
唔該 該晒呢個記者啦。基本上個問題咧就係同正話英文嘅問題一樣嘅，不過都好願意用中文答多一次啦。好多謝你尊重我啦，我有限制大家明白，唔可以評論個別嘅案件。但係一般而言咧我哋香港係強調法治嘅，法治係我哋香港成功嘅基石。香港係個法治社會，法治其中一個重大嘅原則咧就係法律面前人人平等。法律面前人人平等。當一個人有官司啦，譬如話佢有刑事嘅案件，法庭要審理嘅時候，如果你話有聲音話因為佢係乜嘢身份啦，佢咩職業㗎，或者係咩政治取向㗎，或者佢係識得啲咩人啊，又或者有咩邊個有權有勢嘅人，無論係香港啊、海外嘅，幫佢出聲啊，可唔可以早啲放咗佢啊？可唔可以唔好審啊？可唔可以諸此類嘅嘢？而法庭咧就放咗佢嘅話，或者個件案件就不了了之嘅話，你可以想像呢個咁嘅情況係幾個唔公道。因為你只要將一個咁嘅被告人咧同一個無名小卒香港嘅普通人，再普通到唔普通嘅人，如果係有乜嘢事犯咗咩官非喺法庭俾人告，佢冇頭冇面，唔識得人。香港裏邊係一個好平凡嘅700幾萬人裏邊其中一個再平凡不過嘅人，冇人認得佢，冇人記得佢個名，冇人知道佢點樣，冇人幫佢出聲，冇有權有勢嘅人幫佢出頭，幫佢提議交易，幫佢提議交換，幫佢提議要威脅法官嘅時候，佢就要繼續審訊，可能判有罪，可能冇罪，有罪又要坐監嘅時候。呢個社會係幾唔公道嘅社會，我哋會唔會話一個社會應該對某種人就有一種法律，對第啲人咧有第啲法律？你係尊貴嘅人就有一種法律，你係普通嘅人有另一種普通人嘅法律。呢個咁嘅社會咧，我諗係一個好唔公道嘅社會，係唔會令到我哋引以為榮，或者令到我哋做法官嘅同仁咧係一個驕傲或者願意服侍嘅社會。但係我好開心咧，我哋香港唔係一個咁嘅社會，我哋係一視同仁嘅社會，我哋係一個公平公正、法律面前人人平等嘅社會。無論咩人惹咗官司、惹咗官非，要去到法庭嘅時候，我哋都公平公正，按住法律、按住證據、按住所有嘅保障去審案判斷有罪冇罪嘅情況咧。一個咁嘅社會，一個咁嘅司法制度咧，係我哋，亦都係我哋點解我哋咁多法官嘅同事肯去擺低所有嘅嘢嚟服務司法機構，服務我哋香港嘅司法工作嘅一個重要嘅原因。好啦，另外一個問題咧就係都係提翻海外非常任法官啦，咁係咪6個就夠？咁你就不如都唔請住啦，或者點？咁我哋都強調啦，咁法官嘅嘢，如果我哋有海外非常任法官，我哋見到有嘅，有適合嘅好嘅，佢亦都有願意嘅心咧嚟到香港服務嘅時候咧，我哋會好願意咧去接觸佢哋或者嘗試咧聘任佢嘅，亦都當然啦，法官我哋而家有足夠，亦都要未雨綢繆啦。法官我哋話講啦，同所有機構一樣。有入職有升職，有一日會離職㗎嘛。咁始終非常任法官有一日佢可能因為各種嘅原因咧會離職嘅原因咧，咁我哋一定會繼續嘅招聘嘅。但係有一樣嘢我想澄清一點，因為你正話提到咧嗰個改善嘅待遇嗰方面咧嚟招聘法官嗱，呢度兩樣嘢嚟㗎。我正話之前的確係提過，因為人手嘅問題，我哋點樣解決咧？其中一方面我哋檢視同埋改善我哋法官嘅待遇，我係講緊一般嘅法官嘅待遇，特別係想喺本港嘅執業界嘅法律界人士裏面招聘法官個待遇唔可以同佢哋嘅收入爭距太遠嘅問題。但係我唔係講緊招聘海外非常法官，因為有啲好唔公道嘅，特別喺外國嗰啲嘅寫法，尤其是佢哋無論咩原因都好啦，我唔測度人哋嘅背後嘅動機啦，批評我哋啲同事海外非常法官嚟香港，每一次你嚟香港，你有幾多10萬嘅報酬嚟一個月嘅，所以你嚟啦，又搭乜嘢機票，又有人招呼你香港又點咁樣。我諗當然就係呢啲
如果你講得最好嘅，你當佢係唔知情啦，係咪？講得差嘅呢啲真係可能即係惡意嘅攻擊。即係呢啲海外非常嘅法官，你諗下，你講緊啲乜嘢法官，講緊咩名？有一次我睇過 Lord Hoff 90幾歲，佢退休之前或者任法官之前係頂尖兒嘅英國嘅御用大律師，做咗法官係頂尖兒嘅英國法官，退咗休之後係頂尖兒嘅仲裁員啊！佢哋做仲裁員嘅收入都唔知幾犀利，絕對係同出邊嘅當大律師、御用大律師或者香港資深大律師完全嘅收入係都唔知幾多，比起我哋對唔住啦，比起我哋嚟終審法院非常法官嗰個待遇，當然雖然對普通人嚟講嗱，我哋要強調下，對普通人嚟講，包括我哋同比較公職人員、公務員，我哋做法官嘅待遇係好好嘅，係嘛？但係我哋嘅待遇同商業機構已經有一別啦，何況同法律界頂尖嘅法律界人士都有一別。你講緊話佢哋會為咗呢啲香港的咁多嘅相對嚟講咧，我強調相對嚟講，唔好意思啊嘅報酬嚟走嚟香港，所以咧就會甚至乎揞住良心嚟點樣服喺香港做法官。我覺得有時咧，即係呢啲講法係完全嘅唔正確。咁我想講得禮貌啲啦，係咪？我覺得咧，你當佢係唔知情都好啦。但係既然你問到有提到嘅時候咧，亦都有咁多傳媒朋友咧，無論外國會唔會報道我哋今日講咩嘢都好咧，我都起碼我哋本地嘅傳媒咧，唔好唔知道我哋呢啲咁成功嘅，就算佢退咗休嘅退休法官，佢哋嘅收入或者即係個商業市場需求係好高嘅，佢哋嘅時候，佢仍然肯嚟香港1、2年或者3年嚟1、2次審案咧，我哋好多謝佢哋，絕對唔係因為香港嘅報酬啊或者待遇咧嚟為香港做。咁反而我調轉嚟講，你唔好介意我咁長氣。對於你嚟講，佢既然唔係為咗報酬，咁佢為咗乜嘢而嚟咧？既然佢家鄉有人批評佢，佢有咁高嘅榮望，佢犯不着將佢嘅聲望嚟俾人話點解走嚟香港？除咗一個原因，呢啲人係頂尖嘅法官，佢知道邊度地方佢可以繼續嘅秉行公義，發揮去做法官、審案、主持公義嘅職分、職責。佢見到香港有機會，仍然有機會俾佢，唔係做仲裁，而係審案司法。而家正話都有人強調，香港嘅司法唔係淨係商業嘅，各方面嘅範疇嘅法律都有得做嘅時候，佢好珍惜呢個機會，所以頂住外國本土家鄉，佢哋成日睇嗰份報紙，有時鬧佢哋都照嚟香港。所以調翻轉嚟講，我哋香港嘅法治、司法獨立係幾咁實際，幾咁健全，幾咁好。外地嘅呢啲法官究竟幾咁尊重我哋本地人更加應該對我哋自己嘅制度咧好有自信、好有信心先啱嘅。多謝你個提議。
咁就記者會進行咗50分鐘啊，咁我答多2位記者嘅問題就結束記者會。第一項呢位男記者啊，
司長你好明報，我有3個問題。承接頭先中英文行家嘅提問咧，除咗我哋評論個案咧，除咗平等同一個法治嘅原則咧，呢類就住某宗後 high profile 嘅案件，啲外交層面嘅討論咧，你嘅意思係咪對香港法庭咧係冇完全冇影響嘅咧？就會通做一啲形象一啲嘅講法咧，就係如果譬如講我哋個國家地區嘅領導人咧問意見喺外交上有啲人咁講喎，你會俾咩意見俾我哋領導人咧？第二咧就係立法會過去咧就住跟進法院嘅判決而可能否決個別嘅法案咧，過去都有發生過嘅。原則上咧喺履行法院嘅義務嘅過程當中咧，我哋點去理解政府嘅義務？即係佢係咪要就算一次否決咗之後咧，政府嘅義務係咪會繼續存在，直至到佢可能真係有啲具體嘅行動、具體嘅框架咧？最後我想請教有關李義法官佢先前會續任啦。按你嘅理解咧，佢呢個3年嘅續任咧係淨係做3年啦，定係佢會 open 開放做足6年咧？長遠嚟講對 CFA 嗰個 即係接班啊，或者成傳嗰度咧，有冇思考咧？
多謝呢位記者嘅提問咧，我想簡單答啦。第一，我哋想強調啦，我哋法官判案咧係一定只根據適用嘅法律、案情、證據同埋雙方面嘅辯論嘅論點、舉證嘅責任同埋標準嚟判案嘅啫。其他所有外邊嘅意見或者提議，甚至無司法機構內部嘅非嗰個法庭嗰個法官裏面嘅任何意見，包括首席法官行政上講乜嘢都好咧，都係無關重要，亦都唔應該考慮，唔會考慮嘅。咁所以我哋香港法官咧，只係根據我哋話講嘅嘢判案，係唔會俾任何嘅呢啲嘅考慮。咁我哋都係專業嘅訓練嚟嘅，呢個亦都係我哋嘅做法嚟嘅。咁至於話，如果一個國家與另一個國家或者政府與政府，佢哋達成乜嘢行政嘅安排嘅時候咧，當然如果喺任何嘅牽涉到任何人呢個社會嘅管治裏邊，行政範圍內嘅嘢，當然行政嘅機關可以決定做乜嘢嘢。但係如果去到法院嘅範疇嘅時候，係需要法官決定嘅話，法官一定係只能夠根據法律去決定。所以咧，呢啲係一個普通嘅原則，我就會咁講啦。嗱，第二咧就關於嗰個立法會方面又或者係行政機關嘅職能方面，我今日咧就花咗一半嘅時間咧，就講完大原則，我就唔會講到個別嘅案件㗎啦。因為大原則咧就係各司其職，你可以咁講。我哋司法機構，我哋有我哋嘅憲制嘅角色，行政機關有佢行政嘅角色。當然，佢行政機關係一個管治香港嘅，佢係管理香港嘅，所以有好多嘢都關佢事嘅。佢好多嘢亦都可以處理得到嘅，亦都佢一定當然所有機關啦，包括司法機關都係啦，行政機關亦都係啦。基本法第64條亦都定到明，行政機關要遵守香港所有法律啦。明白嘅，立法機關都一定當然要遵守所有法律啦。明白嘅，但係各有各嘅角色嘅。係互相嘅需要尊重同埋分工嘅，呢個係我哋嘅憲制嘅結構嘅設計嚟嘅。司法機關咧要獨立嘅行使呢個審判權同埋終審權嘅咁嘅情況嚇。咁所以呢啲嘅情況喺有行政機關去行能力範圍裏邊，佢應該做嘅嘢，佢需要做嘅嘢，或者個基本法裏邊或者受基本法憲制有憲制效力嘅人權法方面嘅佢需要做嘅嘢，當然我哋相信佢哋亦都會做啦。有啲嘢需要立法嘅時候，亦都唔係到行政機關單方面可以做到嘅時候，亦立法會亦都會有功能，但係亦都我哋嘅憲制嘅設計，立法會亦都有好多佢需要考慮嘅情況啦嘅事情嘅。你明白法院係法院啦，法院淨係。所以我哋淨係考慮法律啦，但係亦都係因為淨係考慮法律咧，有好多嘅嘢我哋唔會考慮嘅。正所以個憲制設計咧，呢方面就法院冇呢個憲制責任，亦都冇咁嘅能力去考慮好多其他嘅需要嘅嘢。但係立法會當然好明白啦，立法會佢嘅立法嘅時候影響成個社會嘅，當然有個法律嘅框架啦，憲制裏邊立法會亦都有個框架，亦都有佢個責任啦。但係佢需要考慮好多嘅事情嘅，好多事情呢啲係法庭唔會考慮，都冇能力考慮嘅。咁成日立法會考慮好多嘅事情，去決定幾時立法、立唔立法、立乜嘢法、立法嘅內容係點樣樣。當然佢哋有，正話我用咗個字咧 ，legislative discretion， 一個立法嘅酌情權。呢個咧係立法會佢哋嘅立法功能嚟嘅。咁係需要呢個憲制嘅分工，行政立法佢哋互相嘅制衡同埋合作，而咧司法機構係獨立嘅行使我哋嘅審判權同埋呢個終審權。呢個係我哋基本法按住憲法嘅31條設計之下，我哋個憲制秩序我哋係絕對要緊守嘅。第三方面咧就提到李義法官嘅呢個，實際佢係一個再任命 reappointment， 佢唔係延任。係現任就係 extension，reappointment， 所以啲字引起注意就係即係話好似個新法官委任到佢一個 職位咁樣，所以亦都需要行政長官得到立法會嘅同意先可以作出任命，亦都任命咧，亦都要報請人大常委會去備案嘅。咁嗱，呢個係我哋實際法律上係有呢個規定嘅。以前亦都有個咁嘅情況，一個人過咗我哋終審法院嘅規定嘅退休年齡，仍然可以再被呢個委任或者係再被委任去終審法院當法官。以前有個咁嘅先例做過嘅。咁根據嗰個有關嘅終審法院嘅條例咧，係委任嘅時候咧係第一次係3年，3年之後咧可以再延任啦。嗱，呢個就係延任啦 ，extension， 再多3年嘅。嗱，至於個終審法院嘅成全問題，呢個係好合理嘅。呢個每一個機構都要諗嘅，因為我之前都講啦，每個機構你問政府又好，問私營機構又好，問邊個部門都好，有人入職，有人升職，有人退休，有人提早退休，一定要成日都要諗住個 succession 問題。但係你以法官就有咁多特別嘅唔同。你如果去調查下，就係今日個演辭都有講，你以法官係我哋香港嘅不可多得嘅法律嘅人才，不單止係香港嘅頂尖法律人才。你翻去 Google 下外國嗰啲司法機構嘅網頁，佢哋判案書，你打個 Rebello 個 PJ 嗰個字落去，你睇下佢哋啲判案書，有幾多判案書係引用 Rebello 法官佢嘅判詞，你就知道咧，佢係喺成個普通法界裏邊，即係我講緊包括外國嘅普通法界，包括我哋嘅海外非常法官嚟嗰啲普通法界裏邊，幾有威望聲望，佢係完全拍得住我哋海外非常嘅法官嗰啲頂尖嘅外國法官嘅。我哋香港有個咁嘅法官嘅時候咧，你應該當係寶嘅。咁你當然我哋明白啦，佢嘅年紀未必係輕啦，但係呢啲年紀嘅嘢都係相對嘅啫。你比起阿 Hoffman 法官咧，佢係好後生嘅法官。你睇下人哋過咗90都走嚟香港嚟幫你做法官，亦都好活躍。我記得有一年我話俾大家聽 ，Hoffman 法官好中意踩單車，朝朝踩單車翻工。我諗你同我都未必做得到嘅時候，人哋都仲肯做嘅時候，你法官肯繼續喺香港服侍嘅時候咧，我哋服務嘅時候咧，我哋好歡迎佢繼續喺香港服務。所以咧，我哋有呢個條例可以再委任嘅時候咧，佢呢個情況咧同我哋嘅繼承咧未必係最大嘅關係。呢個係我哋有香港咁好嘅法官咧，我哋想去如果預置嘅話咧，我哋繼續想去咧，繼續去為香港服務。嗱，至於我哋嘅繼任啊、成全咧，我哋一向都有諗嘅。我哋亦都長江後浪推前浪，有好嘅法官有一日佢會退休嘅，包括我在內都會有一日退休嘅。但係亦都有新嘅法官被招聘，亦都咧嚟到我哋法官行業裏邊咧升職，亦都有啲咧好嘅法官嘅人才輩出，亦都有可能喺出邊嘅加入嘅時候咧，呢方面咧我哋都可以好合理嘅樂觀咧，呢方面我哋係可以成全方面咧會做得好好嘅。多謝大家。
答埋最後一條問題咧，喺第2項第三位男記者，唔該。
你好，大公報記者，兩條問題。第一個係注意到最近CJ 亦都有去到內地同一啲內地嘅法院交流啦，同埋都有一啲內地嘅法院嚟香港呢邊。然後想問下呢啲同內地嘅交流喺司法機構履行職責方面咧，起到啲咩作用或者影響？然後第二條問題係去年就你提到有網絡直播嘅先導計劃，為期2年啦。咁依家已經1年啦。司法機構有冇對於佢有個中期嘅總結咧？多謝。
多謝呢位記者朋友嘅提問啦。嗱，我哋司法機構咧一定要與時並進，對同呢個世界，包括我哋自己國家，包括內地嘅司法機構，佢哋司法方面嘅最新發展咧，我哋非常之留意，一定唔可以固步自封，更加唔可以做井底蛙嘅。所以我哋同外國又好，同我哋國家內地又好，我哋咧有好多嘅持續性嘅交流、訪問、互相借鏡，去咧參考其他嘅司法機構佢哋面對嘅 嘅司法方面嘅各方面嘅最新嘅發展啊、科技啊、審案啊、定位啊、同社會嘅溝通啊、法治裏邊面對嘅挑戰啊、各方面嘅審理案件啦、人嗰個manpower 嘅 situation 啊，即係嗰個人手方面啊、案件嘅情況啊，都有咧一方面咧互相嘅參考去借鏡嘅。我哋同內地咧亦都係冇例外嘅，尤其是咧我去過內地咧好多次訪問，我哋每年都有定期去內地訪問唔同嘅地方，有最進步嘅，當然我哋有首都啦，有去過啦，有上海呢啲大嘅城市啦，我哋啱去過西安啦，有啲比較在發展中嘅地區，我哋對國家咧都想有個全面啲嘅了解，唔同嘅情況之下對法治嘅要求，對個硬件嘅面對嘅處理，對公眾嘅對法治或者司法嘅期望，對科技嘅應用咧，我哋都好希望咧參考嘅。就算係內地去用一個成文嘅法律制度，同我哋普通法制度有啲唔同，但係當中亦都好多可以參考同埋借鏡嘅。尤其是內地嘅科技應用方面係好先進嘅，科技發達得好緊要嘅。但係我哋香港方面有幾多可以參考呢？幾多可以借鏡呢？有幾多話暫時呢方面由於制度嘅差異唔能夠採納呢？我哋都係有去參考嘅。對互相嘅交流，對互相嘅認識，內地嘅法官嘅同仁，對香港嘅普通法，我哋對法治嘅理念，或者我哋審案嘅呢嘅原則，對內地嘅法官嚟講，亦都有，我相信亦都有啲參考嘅價值。另外一個特別嘅地方咧，就係我哋同內地主要嘅工作咧，當然律政司同律政司司長就做咗大量工作。我哋同內地嘅司法互助方面咧，有好多嘅成一啲嘅大家嘅協議啊，互相交流。最比較近呢幾年最多注意嘅就係民商事案件嘅互相嘅承認同埋執行方面啦，同埋咧亦都方面咧就係嗰個公司清盤嘅命令互相嘅執行。呢個係內地嚟講咧有幾個試點嘅，包括上海、廈門同埋深圳都應該係互相嘅執行。呢啲都對我哋香港作為一個國際嘅商業特別包括公司法同埋呢個清盤法嘅一個中心咧，好有幫助嘅。你諗下香港嘅公司法嘅法庭嘅案嘅命令，包括清盤命令咧，可以喺啲內地嘅重要幾個內地嘅試點城市裏邊執行，係好緊要嘅。咁呢方面咧，所以我哋多啲嘅交流嘅情況之下咧，互相了解同埋有啲嘅執行起嚟嘅細節方面咧，互相嘅傾談，令到佢咧更加暢順咧，係好有幫助。第二個問題咧，亦都係今晚可能最後一個問題啦，就係關於呢個轉播我哋嘅案件呢方面。我可以講話咧，過去嗰年咧，呢個計劃係好成功㗎。我哋個終審法院啲案件個咁講收視率唔錯㗎。咁咧就3月我哋有啲案件咧，鼓勵啲朋友你睇下啦，好高水準㗎嘅無論係法官嘅問題啦，或者啲大狀啊嗰啲，或者啲有出庭發言權嘅律師啊，佢哋嘅答辯都好精彩嘅。好方便睇嘅，你俾耐心啲睇嘅時候咧，開頭會覺得啲法律啊或者英文啊用啲字眼深奧啲，但係睇落咧好有興趣嘅，一啲都唔悶嘅。咁你亦都咧知道我哋香港法治好均真嘅，啲法官係問啲問題咧，問到好到，啲律師答得好好嘅。咁亦都有時咧，亦都明白法律咧有時好沉悶嘅，同你睇電視劇係好唔同嘅。但係咧，我哋法官係好專業嘅處理。但係咧輕鬆還輕鬆，呢個對普及香港嘅法治，對香港市民，甚至乎由於網上播咧，你喺外國都睇到嘅認識，只要有心去真心想知道你香港實際真係點嘅咧？係咪喺我哋外國傳媒講成咁嘅咧？定係唔好信啫，自己睇真啲啫，一手啫，唔好睇人2手3手啫。你睇嘅時候睇到我哋香港法庭嘅斷案，包括我哋最終高法院嘅終審法院嘅斷案，好均真、好認真、好有條理、好有道理嘅時候咧，對幫助外國本地增加我哋對司法嘅信心， 對呢個法治嘅普及教育，對我哋年青新嘅一代有志加入法律界或將來甚至投身司法界咧，我希望亦都相信呢個係一個產生一個正面積極嘅效果。我相信咧呢個咁嘅安排咧會繼續落去嘅，好唔好啊？咁多謝晒大家，多謝大家嘅時間。All right, go ahead.
Thanks a lot. So you mentioned several times that Jimmy Sham's case might come back in future. Without touching to any specific case, I know you can't. Just touching on legal principle, I wonder, does that mean the role of CFA is not completed yet when the remedy is not given to an applicant as previously ruled by the court? And what can the court actually do? Can the applicant seek further directions from the court? Is that what coming back implied? Thank you.
Thank you very much. Now, I have not said, and I'm not suggesting, that any party can or cannot come back to the CFA in relation to the remedies granted by the CFA in any particular case. I've not said so. I'm not suggesting any answer at all. So, and of course, I'm not here to express any view on anything that may or may not be done by any parties, or can or cannot be done as a matter of law by any parties. So that is the short answer that I will give in relation to these last questions that have been asked. Thank you very much. 再一次多謝晒大家嘅時間，多謝晒大家。
多謝大家。